Question I got from somebody in our private Facebook group, the Illinois Divorce Support Network, is what happens at a status hearing? I keep going to these hearings and nothing happens. I don't get to say anything. Why can't I say anything? What's going on? Okay, so status hearings are hearings where you step up before the court about every month once a case starts and you tell the judge what's going on in the case. It takes like 2 minutes and the lawyers step up before the bench and they tell the court, here's what's going on in the case. We've submitted XYZ documents. We've done A, B, and C, and we need to get X done. And please give us a continuance for another 30 days. And the court will typically set another court date. So there's always a date on the calendar and advance the case for another status hearing. Now, eventually the court gets tired of the status hearings and wants to advance the case, and the court will force the parties to go to a pretrial conference and then schedule a trial date. So eventually the court gets impatient with waiting around. Depending on your jurisdiction and depending on the rules, there are time requirements for these things. So your mileage may vary, but that's the basic gist. In the status hearing, the parties don't get to talk unless you're representing yourself. If you're self-represented, or what we used to call pro se, you get to speak to the court briefly, but you don't get to have a hearing at the status hearing. That is, you don't get to just start talking about how your spouse has done X, Y, and Z, or that you want temporary child support, or that you've got an issue with custody. It's not like a mini trial or a hearing on the merits. It's just a check-in, basically, to tell the court where things stand and set things over for another date. So if you want an opportunity to speak to the court, there are two ways to do that. One is you have to bring a motion or file a petition. For example, temporary parenting time, temporary child support, or modification of those things. Or you have to get a trial date scheduled where the parties actually get to testify under oath and say their piece. And there's rules on that, of course. Either they're questioned by a lawyer or they testify on their own before the court. But you don't get to just talk in front of the judge and say things about your soon-to-be ex. So that's the distinction. There are hearings and there are hearings. So there's hearings where the lawyers talk or where the parties, if they are their own lawyers, speak for themselves, but it's only procedural, really. It's about the business of the case. And then there are evidentiary hearings or trials where the parties get to testify depending on the situation. So I hope that clarifies it and answers the question. Thanks.